Prenuptial agreements are contracts between two people who intend to get married that set out rules for how the couple's property should be distributed if the marriage ends. A prenuptial agreement is often called a prenup and is typically associated with divorce proceedings, but in West Virginia, it can apply to the division of property in other circumstances, including the death of a spouse. Ware eForms, the largest online database of fillable legal forms. In this video, we'll cover the laws about prenuptial agreements, what couples should do before drafting, and what can otherwise get a valid prenup set aside. And be sure to watch all the way through to the end of this video to find a link to an official prenup agreement that can be used in West Virginia. First, what laws are there in West Virginia about prenuptial agreements? Unlike most other states, which have multiple statutes setting out the rules for prenuptial agreements, West Virginia just has one. But that doesn't mean there aren't any rules to follow. Rather, West Virginia's rules about prenuptial agreements flow from cases that have addressed disputes about prenuptial agreements and from other areas of state contract law. West Virginia law allows couples to use prenuptial agreements to address many different kinds of property, including both real property, meaning land, and personal property. The prenup can indicate that in the event of the end of a marriage, certain property goes to one spouse or the other, to one of the spouse's children, or to another person entirely. One thing to note, although West Virginia's statutes refer to husband and wife, prenuptial agreements are available to both straight and gay couples. The prenuptial agreement can also determine the conditions under which it applies, death, divorce, or both. West Virginia requires that prenuptial agreements can be in writing and signed by both parties. While having the document notarized is not required, it is recommended. So what should couples do before drafting a prenup? A prenuptial agreement is likely to be a sensitive subject even in the healthiest of relationships, and even bringing the idea up could have significant consequences. So there are many things to consider before getting down to the details. Whether a prenuptial agreement is a good idea depends on the financial situation of you and your partner, including the assets you have, children, or other dependents you may bring to the relationship, and any businesses or projects that may change your situation in the future. It may be advisable to speak with a financial professional to see whether a prenuptial agreement is in your interest. Once you've decided that you do want a prenuptial agreement, one thing to keep in mind about West Virginia is that, unlike other states, it's not required that each partner have a separate attorney review the document before signing. It's important that neither party be pressured into signing against their will, but according to the state Supreme Court, it's enough that each party has the opportunity to consult with an attorney. After the agreement has gone into effect, can a prenuptial agreement be set aside? There are a few reasons that a West Virginia court might set aside an otherwise valid prenuptial agreement. If either of the parties was a minor at the time that the agreement was created, then the agreement is automatically void. The agreement can also be set aside if either party fails to inform the other of relevant financial information. Finally, an otherwise valid prenuptial agreement can also be set aside if it is unconscionable, meaning it is grossly unfair to one party. If there's a dispute, it's up to the party that wants to enforce the agreement to prove that it meets these conditions. Click the link below for an official prenuptial agreement form for West Virginia. And don't forget to subscribe to see other videos addressing relevant legal aspects of family and finances.